Well, some international relations experts believe that the U.S. attack on Venezuela and its abduction of its president, Nicolás Maduro, could set a bad precedent globally. Many have described the act as undermining international law and norms. And one of those experts is Advocate Evans Ogada from the University of Nairobi, and he joins us now via video link. Advocate, a very good evening to you. Thanks for joining us and a warm welcome to the late edition.
Good evening. Am I audible enough?
Yes, you are audible enough. Thank you so much for joining us and welcome to the late edition. First of all, from a legal standpoint, how would you categorize the U.S. military intervention in Venezuela? Was it perhaps an act of self-defense, law enforcement, humanitarian intervention, or simply unlawful use of force? What international laws are the most relevant here?
I will call that move by the U.S. Some few days ago as aggression. It is not humanitarian in any sense. And in any case, the norm that has been canvassed by some of the countries in the West as a norm allowing countries to intervene on humanitarian basis has been rejected. It is not agreed to. Now, what is the basis for the intervention in Venezuela? We are told that the United States acted on the basis of a warrant from a federal court in New York to move to Venezuela and arrest a sitting president. Now, that is problematic in terms of international law on several fronts. Number one, there is a reach as to which you can apply your domestic law and to apply your domestic municipal court jurisdiction outside the territorial boundaries of your country. So, for example, South Africa or Kenya, where I come from, cannot effect the warrant, a warrant from our local courts to our neighbors. South Africa cannot go and arrest a head of state in Lesotho. Kenya cannot go and arrest a president from Uganda or Tanzania. So that is the problem we have in terms of international law with what was done by the Americans in arresting President Maduro. And more importantly, there's a
Advocate Ogada, I think we need to push. I think we need to push the envelope a little bit further in terms of understanding sovereign immunity, in terms of getting a broader understanding of territorial consent and use of force standards. So is there any credible legal basis under existing international law that would justify a foreign power forcibly, removing a sitting head of state, even if that leader is accused of serious crimes such as drug trafficking?
Absolutely not. And this has been clarified. There are two cases that I will want your viewers to have time and read.
Yeah.
There's the case by DRC Congo, Belgium, by the ICJ. Then we have one by Italy, Germany on jurisdiction, the reach as to which you can enforce domestic law and authority in foreign countries. The ICJ has clearly stated the parameters of jurisdiction and immunity in both cases. There is no way that you will effect municipal law warrants over a sitting head of state. The only exception is when we come to international crime. And your viewers will remember that we had warrants issued for our former president and former vice president, now president in Kenya, but from the International Criminal Court because of international crimes under the Rome Statute. That you can issue warrants, and those warrants, out of treaty obligation, states will have an obligation to effect. We have a warrant against Benjamin Netanyahu right now. That will compel states to effect those warrants. But a municipal state like South Africa, like Kenya, cannot effect a warrant from its own country to purport to arrest a head of state in his own country. That was wrong.
I'm actually glad that you made that point because so many analysts, describe the absence of a United Nations Security Council mandate as a fatal flaw in the legality of the U.S. action. So in practice, Advocate, Just how critical is the Security Council authorization in these particular scenarios, and why? I mean, taking into cognizance the extent of the principle of sovereign, equality of states, and how that sovereignty protects nations like Venezuela from external intervention, and just how that principle has been challenged in this particular case.
Well, the United Nations Security Council has a peace and security mandate, meaning that if, assuming that the United States felt that Venezuela was a threat to it and in terms of its national security, it ought to have come before the Security Council and adduced the evidence, and authorization for it to defend itself should have come from the Security Council. Certainly, the Security Council ought not and cannot give authority for a head of state to be arrested, because under international law, that cannot happen and should not happen. So in terms of what happened with President Maduro, this is an act of aggression because the Security Council was not consulted, was not involved in any way. If you watch the statement from, I think, an Undersecretary of the UN reading the statement on behalf of Secretary Guterres, they characterize this in diplomatic language, saying that it is disturbing what the United States did. We will be more outright in saying that this was illegal, this was an aggression. It departs from known norms of international law.
Just a quick question before I let you go. I mean, I went through an article, the Asia Pacific Report article, highlighting fears that ignoring international law here could also embolden other nations or the non-state actors to justify forceful actions globally. Just how real is that threat? And maybe can you give examples of where a similar logic has already been used?
Well, if history serves us well, we will remember that World War I was precipitated by Germany, Japan, Italy, moving out of the League of Nations and undergoing this crazy phase of expansion, going and attacking and aggressing against other countries. Certainly, your viewers will remember about Hitler, and Hitler attacking Poland, annexing territory all over Europe. And that contributed significantly to the mess that we saw in Europe during the Second World War. The United States has engaged in a similar action of arresting sitting heads of state. And in 1989, Manuel Noriega, the president of Panama, was arrested in a similar manner, and that was condemned because you cannot go for a sitting head of state in that manner and in a cavalier manner, arrest him and put him in handcuffs. Remember, the immunity, the dignity is not for Maduro the person, it's for Venezuela. So when you treat him in that manner, you're essentially disrespecting Venezuela.
Adv Ogada, great chatting to you. Thank you so much for sharing your thoughts with us. Interesting times, more especially because there's various schools of thought with regards to whether there's meaningful differences between framing this as a law enforcement operation versus an act of war under international law, especially given the involvement of U.S. military forces inside Venezuelan territory. Great chatting to you. Thank you so much for joining us.